My name is John Weiss, and I'd like to welcome you to the annual health law update for hospitals. As Bethany mentioned, Gilpin Gavin has been a proud sponsor of the Alabama Hospital Association for more than 20 years. We're also glad this year to help celebrate the 100th anniversary of the Alabama Hospital Association. Helping me this morning will be Chris Richard, Greg Everett, and Brent Wills in our healthcare department, and we'll hope to try and cover most of the subjects that might be of interest to hospitals. We obviously will not cover everything. What we want to try and cover is, first of all, we're going to do an OIG and DOJ update. That would be the Office of Inspector General in the Department of Justice. Then we're going to look at COVID-19 1 year later, all the various issues that are associated with that. We have an Alabama update, which will cover legislative and case law developments during the year. Brent's going to cover, bring us up to date on privacy and security matters. And then Greg will wrap us up with a quick look at the OIG work plan. This is the obligatory disclaimer slide that basically says we're not giving you legal advice. We're just discussing legal issues. And if you have issues that need to be addressed, we encourage you to contact your counsel. Of course, Gilpin Gavin would be delighted to help you with that as well. So there's the disclaimer and commercial all in one place. I include this slide every year just to keep a clear perspective on where you are and what you're doing. A reminder that you work in the most highly regulated industry imaginable, that you have all of these regulatory requirements, and then you have a plethora of agencies, accrediting organizations, government agencies, insurers, bondholders, whistleblowers, the media, all looking over your shoulder to making sure that you're doing it correctly. So what we're trying to do this morning is to help you in that endeavor. So let's dive right in to the OIG DOJ year in review. What we're going to try and do in this first segment is a quick overview of the fiscal year 2020 and what the government views as some of the highlights of what they've accomplished this year. Then we're going to look at the government enforcement activities over the last year, some of the DOJ and OIG cases and settlements. And we're going to look at the infamous Sprint regulations. We're going to kind of jump out of the Department of Justice and over to Centers for Medicaid and Medicare Services for just a bit on that. So fiscal year 2020 was not the bombastic year of some of the prior years in fraud recoveries. Total fraud recovery for the Department of Justice was only $2.2 billion. That's lower than any other year on this chart. And the healthcare fraud recoveries totaled only $1.8 billion, which again is the lowest number on the chart. Reasons for that may be several, but I think you have to assume that COVID shutting everybody down for several months at least, and with respect to government agencies, maybe longer than that. Courts in some jurisdictions shut down. So there are various factors that play into that, but clearly not the kind of year that they had in 2019. Other developments with respect to the last year from the Department of Justice, over 1,100 new criminal healthcare fraud investigations, over 400 criminal cases involving about 680 defendants initiated. They convicted 440 criminal defendants during the course of the year. On the civil side, over 1,000 new civil healthcare fraud investigations. So a lot going on, not as much as in past years, but still a lot going on from the Department of Justice. Whistleblowers remained active with 672 key TAM suits filed this year. That's a rough average of 13 new cases per week during the course of the year. And the return on investment for the Department of Justice remained pretty high. On the 3-year rolling average, they were up by 10 cents to a total of $4.30 recovered for every dollar spent on enforcement action. So clearly it's an endeavor worth their effort from a strictly financial standpoint. 2020 was also an interesting year for the OIG. Again, not as dramatic as last year, but still a lot of activity. Over 2,000 individuals and entities were excluded from federal programs. 578 criminal actions against individuals and entities were initiated, and a little over 780 civil actions were initiated. Trends that we're seeing, whistleblower cases continue to be a significant, I will use the term enforcement tool, but a significant tool for the Department of Justice with respect to these matters. Fraud recovery efforts still are providing a pretty good return on investment for the department, so you won't see them slacking off in that regard. And I think most significant is we are seeing a continued, if not heightened, focus this year on the individuals behind the various fraudulent activities. I think as we go through this, in fact, as I was going down the OIG and the Department of Justice's list of settlements and cases from the year, I had a hard time finding cases that were, for example, hospital cases. In years past, you would have 10 to 12 to 15 major hospital cases with big numbers associated with them. This year, there are a plethora of individual cases involving owners, employees, executives, and physicians. So that is a growing trend that we're seeing. Now, you can't talk about last year without talking to some degree about COVID. And let's just say that, the fraudulent folks have an equation. COVID plus the government equals what? It equals money. So, actually, that was supposed to play the rest of that for you, because the rest of the words are important, but it's not playing. So thank you. We will put in a plug that Spotify didn't comply. But as Pink Floyd noted in that popular piece, grab the cash with both hands and make a stash. A new car, caviar, 4-star daydream. Think I'll buy me a football team. Some of the folks, obviously, this year took that to heart. We had 6 acts that provided resources, funds, and money in the midst of the pandemic. Now, most of you are familiar with all of these, and I won't go through them, but they also provide, unfortunately, wonderful opportunity for creative yet deviant minds. There are also reporting and record requirements that are fairly significant, and Chris is going to follow up on those later, but they're periodic reports. The portal is open for reporting the use of funds for more than $10,000. The government audits are going to be significant. OIG revised its work plan to address provider relief fund payments, and Greg will touch on that later. In January, OIG announced a new audit for Home Health Agency telehealth project for telehealth waivers under the public health emergency. Each agency has its own audit team, obviously, and then the bad news is the government has retained a bunch of outside firms to also help audit the $178 billion provider relief fund. So there's going to be a lot of government activity looking over your shoulder with respect to all of these funds. By March of this year, the DOJ had charged more than 470 folks with crimes, that's crimes related to the pandemic. And by May of this year, there were 14 additional defendants with 143 million in false billing, and 50 medical providers had been excluded just in that time frame. One of the most interesting scenarios I came across was a provider offered COVID testing to senior living facilities, medical offices, drive-through sites as a scheme to collect personal information, saliva, and blood samples. Then they turned around and used that information to submit claims for unrelated, medically unnecessary lab tests, cancer testing, genetic testing, allergy testing, etc. And the results frequently were not even reported to the patient or the physician. Then you'll note that these folks then turned around and purchased exotic cars, luxury real estate, probably some caviar, but no football teams. I do think that somebody from the Department of Justice does monitor the exotic vehicle market, because all of these folks seem to get caught, have been messing around with exotic vehicles. So there are a number of representations that are made under all these programs, which are going to create potential for False Claims Act risk. So you need to carefully assess the certification language and review the terms and conditions of each respective program. There are some key risks that we think you probably ought to think about. The first is, were the funds used with respect to qualified losses or expenses under the program? Did the facility comply with the terms and conditions of that particular program? Be careful that you don't double dip. That is, using funds from multiple programs and apply them to the same expenses. There's potential for inaccurate reporting, and then of course there's a failure to maintain the required documentation. So let's talk then a bit about significant court rulings in the last year. And we have to start out with one of my favorite slides. I think I've used this slide for almost 10 years, but rumors of ACA's death are clearly premature. The case that we dealt with this year is California versus Texas, in which the Texas District Court initially ruled that the ACA was unconstitutional. You recall, after the tax provision was removed and the law does not have a severability provision, therefore, the district court struck it down. The Fifth Circuit affirmed that, and the Supreme Court, in a 7-2 decision, held that the plaintiff states did not have standing. This is basically a procedural kind of decision, which unfortunately leaves the door cracked for further litigation on the subject. So stay tuned and we'll see what next year brings. Then in the Seventh Circuit, the Said case is fairly significant. This is, in this situation, the court held that monthly payments for client information that was later used for marketing for home health services was not a referral under the Anti-Kickback statute. And you recall, the Anti-Kickback statute says that the statute is violated if you solicit, receive, offer, or pay any remuneration directly or indirectly to induce a person to, quote, arrange for the furnishing of items or services paid for by a federal healthcare program. So the Seventh Circuit held that the trial court failed to apply the definition of referral under the Act correctly, and said that referral is much broader, that it encapsulates both direct and indirect means of connecting a patient with a provider, i.e., arranging for the furnishing of items or services. So on remand of the case, the trial court remarkably then found that referrals in this situation were a violation of the Anti-Kickback statute. U.S. versus Shaw. This is a podiatrist who accepted payments in exchange for writing prescriptions for compound medications. And in this case, the judge instructed the jury on the one purpose instruction. Under the anti-kickback statute, you'll recall that you have violated from a purpose standpoint or intent, as long as one of the purposes in entering into the arrangement was for the referral of patients, then you have violated the act. It does not have to be the primary purpose, just one of the purposes. On appeal, the court held that one person's instruction was actually in error, because in this situation, we're dealing with a podiatrist who was accepting the payments. That is, he was the payee, he was receiving the payments. And the court drew a very interesting distinction, noting that the payee prohibition on soliciting or receiving payments does not require proof of the defendant's purpose, while the payor prohibition, that is the one offering or paying remuneration, does require purpose. So it looks like, at least in the 11th Circuit, which is our circuit, that there may be a different standard of intent for a payee or a payor under the anti-kickback statute. It may turn out to be a fairly significant development. Then the 4th Circuit in U.S. versus Mallory, this is a lab that paid a percentage of revenue commission to an independent contractor company, who then in turn contracted with independent contractors to basically go out and make sales on behalf of the lab. The court held that a volume-based commission compensation paid to an independent contractor does violate the anti-kickback statute. Again, arranging for the furnishing of or recommending the purchasing of healthcare services. This has major implications for clinical labs and pharmacy companies. It's also consistent with the 11th Circuit's case in U.S. versus Vernon, this has sort of been the rule in our circuit already. I would point out that if you have any commission-based compensation arrangements, that those need to be reviewed and probably replaced. Okay, National Health Fraud Day. Well, actually, there's not a National Health Fraud Day, but you'll recall years ago when Jeff Sessions went in as Attorney General, he started the practice of rounding up a large number of health fraud defendants all on one day. In fact, I think the first one they arrested over 600 people on that first day. And the Department of Justice, FBI, OIG, DEA have all joined hands basically to do this every year. Last year, you can see they had 345 charged, $6 billion in false claims, so forth. This year, again, in September, they only rounded up 138 defendants in 31 federal districts for about 104 billion in alleged false claims. Only about 42 professionals, doctors, nurses, licensed medical professions, were charged. But they broke it down this year for us by scheme, for lack of a better term. And the number one scheme was telemedicine for about 1.1 billion. These are DME, genetic testing, pain medication pharmacies. And the telemedicine executives were apparently paying doctors and nurse practitioners directly to order, quote, unnecessary durable medical equipment, genetic tests, pain meds, etc. Then the DME companies, labs, and pharmacies turn around, in some cases actually pay for the referrals, and in others simply fill the orders and in exchange for an additional kickback or bribe. This, we'll talk in a minute, but this is sort of consistent with several of the operational investigations that DOJ has been doing. Note at the bottom, proceeds from these activities were spent on luxury vehicles, yachts, and luxury real estate, but no football teams. So The second biggest number, for lack of a better term, were COVID-19 fraud cases. In other words, good old-fashioned types of fraud. About $29 million worth of claims there. Basically misusing patient information to submit claims for unrelated and medically unnecessary lab tests. Frequently, this is genetic testing, but it can be other types of testing. Also, there was significant misuse of provider relief funds, which were used for personal items like Las Vegas gambling and luxury cars. But, as you might have guessed, nobody bought a football team. Opioid distribution was another big component. This is straight up illegal distribution or prescribing of opioids. They had 19 defendants who prescribed over 12 million doses. That's a lot of pain freedom. And then finally, sober homes, which, you know, this was kind of a new concept, showed up a year or two ago. About $14 million in claims that they're looking to recover here for test treatment of patients that were seeking treatment for drug and alcohol abuse. This seems to be particularly a problem in California, which the department refers to that as the Malibu Mile, and in South Florida, which is referred to as the Recovery Riviera. Now, I don't really plan to go through this in any depth, except to say that the important thing about these arrangements is that they happen in places that have sunny environments where people want to be. These are usually young adults under the age of 26 who are conveniently still on mom and dad's insurance. And so they are shipped off to these sunny locations where they can live for a while they're undergoing treatment. And there's various ways that the money flows here, but the important thing is under ECRA, if the claims are filed with respect to just straight up ordinary insurance companies, no federal healthcare programs, you're in violation of ECRA. This is developing industry for the Department of Justice, to say the least. They're spending a lot of time and energy on prosecuting these. If you're in South Alabama near our sunny beaches, you may want to just kind of take note of this. If somebody offers you a deal that's too good to be true, you may want to look and see that it probably is. Telemedicine schemes generally, COVID-19 has been a good thing from the standpoint of accelerating the use of telemedicine in a good way. However, you need to be careful. We've had a number of clients who were from the practitioner side, as a matter of fact, who have been sucked into some of these pretty much unaware. And you don't, you know, unfortunately, once you're sucked in, it's kind of hard to disassociate yourself. But there's been a series of what they call operations. Several years ago, we had Operation Brace Yourself, which was a nationwide telemedicine scheme with call centers in the Philippines and throughout Latin America. The proceeds were laundered through various international shell corporations and used to purchase, yes, exotic cars, yachts, luxury real estate, but no football teams. Then we had Operation Double Helix, which this is basically a genetic testing scheme, but it's very similar to Operation Brace Yourself. The labs are paying kickbacks to the physicians in exchange for referrals for unnecessary genetic cancer testing. The physicians usually didn't see the patients or had a very brief telephonic conversation, and the tests frequently were not provided to the patient or the primary care physician. Then, yes, somebody in Washington does sit around and come up with the names of these. We had Operation Rubber Stamp, which again involves individuals and companies that were collecting patient data and then selling it to DME supplies, pharmacies, and labs. Patients then are lured in with the promise of free DME or lab tests or medications. The telemarketing company pays the doctors and nurses to provide the unnecessary orders. And then the interesting twist on this one this year was the COVID twist, in that a lot of these were using COVID testing as a means to solicit information, then turn around and submit the additional tests. Then finally, we have Operation Happy Clickers. Happy Clickers represents basically the tendency of the professionals involved to simply quickly click on standardized orders for medical braces, cancer genetic testing, and other tests without really reviewing the patient record, determining medical necessity, or having any type of meaningful telephonic conversation with the patient. Okay, real quick, we're going to talk about nursing homes and rehabilitation services, because several of you have nursing homes in conjunction with your hospital. First of all, last year, we had the national focus on targeting grossly substandard care and understaffing, insufficient infection controls, these types of things, as part of a national nursing home initiative. You notice that a lot of this national initiative stuff, you know, Operation Brace Yourself, Operation Happy Clickers, National Nursing Home Initiative. A lot of the enforcement agencies trying to work together to battle what I would call, in these cases, true fraud, as opposed to people making mistakes. The main point I want to make with respect to this segment on rehab and nursing homes is we are still dealing with the Kindred Healthcare legacy. You remember, Kindred Healthcare was a situation where a large healthcare provider was extending services, ramping up the rugs that they were using, the number of minimum hours, et cetera. It was a pretty good scheme. They were producing a lot of additional revenue. The government came in and cracked down on Kindred, which was a huge provider of these services. And now they've basically gone all over the country applying that to everybody else, because apparently everybody else was using the same methodology that Kindred was. So interface rehab, 11 skilled nursing facilities, they had alleged ultra high levels of rehab without regard to medical necessity. That's a consistent factor. They were pressuring their therapists to meet pre-planned targets without regard to the medical record or the patient needs. $2 million settlement. Longwood Management, same kind of scenario. 27 facilities, there was systematic effort to increase Medicare billings through submitted claims for medically unreasonable, unnecessary, ultra high rehab levels. And again, they were pressuring their therapists to provide care to meet pre-planned targets. $16.7 million settlement. Then Montclair Center in New York, 11 facilities, again, kept keeping patients longer than necessary, put patients through higher levels of rehab than clinically needed, and pressured staff to engage in these practices. Then we come to the Sava Senior Care, which is an outfit out of Tennessee, although their main office is in, or the case is out of Tennessee. Their main office is in Atlanta. This was a whistleblower case. Again, the whistleblowers are going out there and finding these based on the Kindred Healthcare legacy as well. They alleged that therapy services were not medically necessary, and DOJ intervened. These folks operate about 200 nursing homes in 23 states, so we're talking about $1.4 billion in Medicare reimbursement. The government asked for treble damages. I wasn't good at math, that's the reason I went to law school, but if you do the math, that comes to about $4.2 billion in claims. This case was litigated for in excess of 3 years. And then in December of 2018, it was stayed for settlement talks. So we said, stay tuned, right? All right, well, stay tuned because settlement talks ended with a settlement for a tune of about $11.2 million, and the court also dismissed several similar qui tam actions that were brought separately from this. So it's kind of interesting to me, we start with a $4.2 billion potential recovery and end with an $11.2 million settlement. I'm sure that Savas Senior Care is not necessarily happy with that. They have to come up with the 11 million, but in the scope of things, it seems that perhaps that case was not as rock solid as originally thought. So the moral of the story is Kindred Healthcare legacy, beware of aggressive rehab protocols that are similar in any way to the Kindred model, and make sure that your medical record supports the treatment that's being provided. That's the short moral of those cases. Then this is a quick case filed in California back in June, alleging kickbacks for medical director agreements. The nursing home engaged physicians as medical directors who, quote, promised in advance to refer a certain number of patients. So apparently in California, the going rate is 10 patients for $2,000 a month. It's just your basic kickback argument. Again, be careful with respect to your medical director agreements that they are in fact supported by fair market valuation and that you are paying fair market value for what you're getting and that you're getting what you're paying for. Hospice, real quick, continues to be a focus. This is a simple case of an operations manager who was out recruiting patients from hospitals and medical practices by offering, you need to write this one down, this is great. We offer hospice that you don't have to die to use. Unfortunately, that's not what the statute says. So he got 27 months in prison and has to pay $150 million in fines. He was also using some sham medical director agreements to encourage physicians to falsely certify that the patients were terminally ill and was pressuring his employees. This is the first criminal hospice fraud case to go to a jury. And obviously not a good outcome for this operations manager. But you got to admit that's creative. Hospice that you don't have to die to use. You know, the focus on hospice continues to be false certification or admitting patients who are basically not terminally ill, that do not have a 6-month prognosis that's required, and falsifying records in many cases to indicate that they're eligible and paying bonuses and kickbacks for enrolling those patients. So if you have a hospice program, just make sure that you don't have anybody doing any of these things because this is where the focus is. Home health, real quick. This is a federal prosecution where the owners of the agency were arrested. That's as far as we've gotten so far, but they allegedly paid to sign up home health services, provided free transportation to patients to the doctor's offices and covered co-pays for doctor office visits, and created, this is the one that's going to get them into deep trouble, created phony medical records. Elite Home Health, the owner was sentenced to 5 years in prison for really running a shabby operation with respect to Medicaid eligible children's services. So represented that an RN did things when the RN didn't, or the person who did it was not an RN. They used fraudulent credentialing information, claimed services to families who were not retained by Elite. So basically they were filing claims for services for folks that had not retained them to do that. So this is classic fraud. I think the important thing to note with respect to the nursing homes, hospice, home health, you'll notice a focus on going after the individuals and actually sentencing the folks behind these schemes to time in prison. The focus for home health agencies continues to be performing medically unnecessary procedures, billing for services that were not actually rendered, which I think it's easy for people to think they can get away with that because it is a remote kind of activity. And then billing for skilled services that were actually conducted by unskilled, uncredentialed folks. And then we had seen some situations where they're actually forging physician signatures when required for reimbursement. All right, so that brings us to our favorite subject, which is hospitals. And like I mentioned at the outset, normally when I review the list of cases and settlements from the Department of Justice in particular for the year, there are a large number of hospital-related cases, frequently dealing with stark violations, False Claims Act situations. This year is a little bit different, and I think you'll notice that the focus continues to be on the individuals. For example, in this situation, the hospital overpaid in purchasing a doctor's practice and his surgery center. The price they paid exceeded fair market value, and it wasn't commercially reasonable. They also way overpaid him with respect to his employment arrangement, which was incidentally tied to the volume and value of referrals, which everybody on this call would know is a no-no. And then they billed for one doctor's services using another doctor's enrollment information. So the bottom line is it was settled for $37.5 million, but what I want you to note is it's not just the hospital. It's the hospital, the CEO, and the doctor that was involved are involved directly in the settlement. In the University of Miami Medical Center case, this is a situation where the hospital failed to give the required notice to patients who were using its provider-based facilities. If you have a provider-based facility, you're supposed to provide a certain notice to the patient that tells them with respect to their copay and deductibles. And I believe it's actually a notice with respect to Part A and Part B. So they were billing, in addition, they billed medically unnecessary lab tests for kidney transplant patients. They had a certain protocol set up for all transplant patients when they came in. They had a set of protocol tests, and the government alleged that these were not necessary for all transplant patients. Ended up with a $22 million settlement in that case. Texas Heart Hospital. This is just classic stark anti-kickback situation. The hospital was physician-owned, and it had a requirement in its organizational documents that the physician, to be an owner, must meet a yearly requirement of 48 patient contacts per year. Obviously, patient contacts means seeing the patient in the hospital. That ended up in a $48 million settlement. And then here's one that actually is sort of interesting. This is Spine Frontier case, which we looked at last year. And Dr. Chin is the CEO of Spine Frontier. And he came, this is a KETAM case that the Department of Justice intervened in. And he developed spine implant device. He's a device manufacturer, implant manufacturer. And he, through a series of other entities, he was paying consulting fees to physicians to give feedback on the product. The problem is the consulting fees generally related directly to the number of devices that were implanted. And so the Department of Justice intervened in March of 2020, and we said last year, stay tuned. If you stay tuned, you'll find that Dr. Chin, who was the CEO of Spine Frontier, and his CFO were arrested and charged in connection with the kickback scheme and bribes that I described. They basically entered into contracts with surgeons to pay anywhere from $250 to $1,000 per hour for purported consulting, but there was actually very little consulting, and ended up paying various surgeons between $32,000 and $978,000 a year, based predominantly on their use of their implants. Now, there's a case in the DC circuit called Blackstone Medical that basically holds that downstream kickbacks can taint a hospital claim, even though the hospital had no knowledge of the kickback. So in this case, if these physicians are getting a kickback from Spine Frontier and then ordering the implant and implanting them in a procedure done at the hospital, there is potential concern for the hospital that when it learns of this, that it is sitting on an overpayment, and the question then becomes whether they have an obligation to repay under the 60-day rule. That's something to be careful of. That's why we generally recommend that, particularly in your employment agreements with physicians, that you make sure that they disclose any and all relationships they might have with device manufacturers or developers, so that you're aware of any situation that might lead to that type of overpayment. This case, it's really a holdover from last year, except that this year the surgeon ended up settling for $4.5 million. I want to jump on through here because I'm running out of time. But these are both voluntary disclosure cases. Northern Ohio, the Cleveland Clinic acquired that system and then determined that they had a bunch of contracts that were in excess of fair market value, and they self-reported. Same thing is true below in Blessing Hospital. They determined that they had a physician implanting medically unnecessary stents, and they self-disclosed. Ascension of Michigan, this is a quality of care situation. Basically, the hospital brought in a third-party physician to review the quality of care and determine that a number of these procedures were not medically necessary. Again, under the 60-day rule, they resulted in an overpayment for both the professional and the facility fee. They self-disclosed and settled for $2.8 million. I'm going to skip over the rest of the hospital focus here in order to get to the regulatory sprint statute. This is a proposed set of revisions to the Stark and anti-kickback statute regulations designed to remove barriers and to facilitate value-based billing and that sort of thing. Originally introduced in October of 2019. They went final on January 19 of this year. The anti-kickback statute put in 3 new value-based safe harbors and modified the definitions of EHR and personal service arrangements. Little change in the requirements for methodology, and that is the comp being set in advance. And also they added local transportation. They increased the local transportation from 50 miles, 75 miles for rural facilities. But I want to jump real quick on the Stark changes. Again, 3 new exceptions for value-based situations, but we want to focus on these modifications to the definitions of fair market value, volume and value of referral, and commercial reasonableness. Fair market value, the new regs say, is the value in an arm's length transaction consistent with general market value of the subject transaction. Only dealing with government regulation would you have a definition of defined term that's defined by another defined term. So we now have to look and see what the definition of general market value is, which is the price that assets or services would bring as a result of a bona fide bargaining between well-informed parties that are not otherwise in a position to generate business for each other. Pretty similar to what it used to be. The important thing is in the commentary, the government said that fair market value can take into account specific circumstances of a transaction. So for example, if you are hiring a specialist who is a nationally recognized specialist, then the rules with respect to how you might determine fair market value for that physician's compensation is going to be different than if you were just hiring a guy right out of medical school. The other interesting thing that they said is that survey data is a very appropriate starting point, but it is not dispositive of the matter. And they also dispelled the notion that, which they had taken previously, that any compensation over the 75th percentile was potentially in excess of fair market value. Obviously, they have done away with that and stated that. So that the commentary here is very, very helpful. The volume or value of referral. Now, again, as I mentioned, I went to law school because I didn't like algebra or calculus, but they have defined volume or value with a formula. And the formula reads so simply: take into account volume or value of referrals only if the formula used to calculate compensation to or from the physician includes the volume or value of referrals as a variable, either increasing or decreasing the amount of compensation in a way that directly correlates with the compensation with the physician's referrals generated. Yeah, that's about as clear as this. But if you like formulas, that's what we have now. So I think the bottom line is it's a question of increase or decrease in compensation that positive correlates to the number or value of referrals. Then there is, we finally have a definition for commercial reasonableness. We've been functioning under this statute since 1995 and never had a definition of the term commercially reasonable. So the government has said that commercially reasonable means that it furthers a legitimate business purpose and is essential in light of the characteristics of the parties, including their size, type, scope, and specialty. The most important is they state in the rule that the arrangement may be commercially reasonable, even if it does not result in profit for one or more of the parties. You will recall that the Department of Justice and many plaintiffs' lawyers were trying to argue that if you employed a physician and his compensation resulted in a loss to the practice based purely upon professional fees, that in and of itself, by definition, is a commercially unreasonable arrangement. CMS has stated within the context of the rule that that is not the case. It's a direct response to DOJ and plaintiffs' lawyers saying that it's not commercially reasonable for a hospital to pay a physician more than their total professional fees generated. So again, good news lurking in the Sprint regulations. There were other modifications. I'm just going to kind of trip through these. There's good news with respect to reconciling a transaction. You get to the end of a recruitment arrangement. For example, you have 90 days to reconcile the payments under your documentation before any of those payments constitute a violation of STAR. It's also important to note that there's a new exception, exception Z. Yeah, we're down to Z. Limited remuneration to a physician. This is, on first blush, doesn't look particularly helpful, but it's up to $5,000 per year in the aggregate. You must pay fair market value. It must not be based on volume or value of referrals, and it's got to be commercially reasonable, but there's no requirement in writing for signature, and there's no requirement for signatures. Example is potentially a situation where you start an arrangement in November or December, but you don't get it properly documented. Then it's possible that if you didn't pay more than $5,000 in November and December, that you can at least get that part of the arrangement under this new exception. It's not over till it's over, because they propose new changes to the Stark rules in July. So we had final revised rules for all of 6 months, 7 months. They're revising the indirect compensation arrangement, unit compensation, and personally performed services, which is all probably more technical than most people on this call want to know, but it keeps folks like us in business. Real quick, trends to watch, the Stark anti-kickback changes, obviously the Sprint modifications. Be alert to your COVID money. They're going to come audit it, so make sure you have records and documentation to support what you did with it. Continuing the opioid crisis, continued focus, increasing focus on individuals, owners, CEOs, CFOs, practitioners, recruiters, etc. Telemedicine abuses, which dovetails with the COVID money situation to a large degree, are going to continue to be a focus. And don't forget, they have your data. Watch your data, because the government's watching your data. If you have an outlier, you need to be investigating the outlier now, because you're going to hear about it.